a city that never sleeps. A lone guitarist makes his leaps. Fingers dance, strings sing a tale of a dream that feels so frail. Echoes fill the silent night. A lost love, a heart so tight. But in this cold, hard world, hope's just a fleeting word. Oh, dreams whisper, oh, dreams sigh. In the darkness, they take flight. Heartbreak echoes, lonely cry. In the cold, hard light, guitar soars through the stormy skies. A melody that pierces the eyes. Love's a memory, a distant dream. In the shadows where whispers dwell, like guitar sings of love's farewell.
I just wanted to know if
Echoes of the hard ones told, now lost in the night's cold fold. Secrets hidden deep within, tales of love that could.
All right, guys, let's screw the opening. That's choppy sometimes. I don't really know why. I guess I got to try to make a smaller file. Sometimes I reboot the computer so it's fresh all the time before the show, and sometimes it comes out good. Sometimes it's annoyingly choppy like that, so I apologize for that. But good to be back. Let's see if I can work on this lighting here. I haven't sat in front of this mic for a while, so let me try it without this thing here. It's very hard to get lighting correct on these things. It's too dim and it actually makes you look pale. But obviously too much light that makes you look pale. So try it this way. No, that looks dark. I don't know. This technology always seems to escape me. Let me see, try turning it down. All right, that's a little better. All right, thanks guys for being here. So we got a really good show tonight. I'm really looking forward to this afternoon. In a little bit, I'm going to have on Margaret McLean, who is Court TV's latest regular in the lineup, discussing the Kaen Reed case. So you're going to see her. You've been seeing her several times, and you'll see her multiple times next week. I'll be on. I'm not sure how many times next week. I'll at least be on Tuesday, and it sounds like some other days. They haven't committed to their full lineup yet. So, just doing my part to try to get a certain side of the case out there. That's why I do it, to try to get some balance. Joe does an outstanding job on it. And so the regulars like me, Joe, and Nick Rocco, who've been doing it for a year, we have a little bit of an advantage because we're now very practiced in that style. I think I've had maybe 100 appearances of being able to reply in these quick sound bites. You got to be able to give an answer you don't want it to be less than a minute, but you don't want it to be more than, like, say, a minute and 20 seconds. So it's not always easy. It can be a little stressful trying to do that. But as any show, I want to start with thank you. It's important to start every day with a little bit of gratitude. And we all go through our lives maybe neglecting that. I know I have for most of my life. And so I start out with thanking, as far as this channel, my moderators, Joe and Thomas Fleming, who do a great job. And I think our chat is some of the most conducive that you can find. Obviously, most of our chat tends to be on one side, but we do work hard to try to be welcoming to reasonable people on the other side. And we don't want to have an echo chamber. What we aim to have here is objective analysis that looks at each individual piece of evidence, in this case or any case, in an objective, neutral way. And because a real problem with every single human being that has ever walked the earth is something called confirmation bias. And this is where you've already kind of made up your mind on something. And now every single piece of information that you get, you kind of just naturally and automatically, your brain does this on its own, sorts it into the pile or interprets it in some kind of way that reinforces the belief that you already have. That's called cognitive bias. And it's a big problem in science, in history, it's in cultural issues, and it's a problem in criminal cases. But it's something that the police are subjected to. That's why they get tunnel vision. But it's something that affects all of us in the public too. And there's a two-step approach to limiting or getting rid of cognitive bias. One is first recognizing that it exists in every human being, including you and me. If you can't recognize that, then you don't really even want to get rid of it. And then two, you have to be diligent. You have to work at it every single day. So every single piece of evidence that obviously lately we're mostly discussing the Kaen Reed case, and every single individual piece of evidence taken in isolation, you have to kind of take it out and put it up at different angles under different light. Try it out from every scenario. Don't just put it in the scenario that works for your side. Because when you do that, you're going to end up making mistakes. And I don't care what side you're on, you don't want to make mistakes. It'll end up really like if you're in a public debate, like if you're behind a mic like I am, or if you're posting on Twitter or something, those mistakes are going to come back to bite you because you're going to lose credibility. And so you don't want to do that. So I work very hard at that, but it's something you have to always work at because we're human beings and we're always going to have that cognitive bias. So another thing I want to talk about, I don't think I'm going to play it because knowing Grant, he'll sue me or something. But the audio clips that I've gotten probably 40 messages on that Grant posted a couple of days ago. I think there was some other person had sent him these clips. I didn't recognize the name. And I guess Murder My Maestro, I think that's Roberta's guy, was involved. I don't know. My response to this has nothing to do with them or with Grant. I'm not accusing them of anything wrong, any wrongdoing, anything deceptive. I want to just state that from the outset. But I have a history on this here, separate from that. So last year during the trial, when the voicemails first came out, Karen's voicemails to John, somebody who I trust then and trust now would completely sent me a version of the last audio clip, the last voicemail. And what they told me was that that clip, that voicemail showed Karen saying, "John, is that you?" And the time of that voicemail was from 5:23 when Karen was out searching. So the implication was that Karen was driving down Fairview and saw John buried in the snow and sobbed, "John, is that you?" So I sent that clip that day to Court TV because I was going on that night. And I said, "This could be big. Can you play this?" Now, on national TV now, they played the clip, but they did not play the clip that I sent them. They played the actual clip that was played in court. And I've heard this clip many times since. I don't know what that clip that was sent to me, where it originated. I don't know if it was deliberately altered. Probably not, but it wasn't accurate. It was, when you listen to those clips, the way they were played in court, it's kind of clear that what Karen said was, "John, where the fuck are you?" Which is very different. And I was made to look like a chump on court TV. I'm sure it's not the first time, but I don't like putting out false information. So I was duped. Now, maybe duped might be too strong a word because I'm not saying that somebody intentionally did it. I don't believe that. I'm sure of it. But at the end of the day, I was willing to go on national TV and talk about a clip that wasn't actually verified and was pretty quickly shown to be different than the one that was played in court. So So I don't want to make that mistake again. And this clip that was put together is way worse than that. It's clearly edited, and Grant has said it's enhanced. Now, enhanced means altered. An altered clip cannot be used as evidence. So that what they have there cannot be used in court. But we shouldn't rely on it either, because I have done a lot of video enhancing. I'm sorry, audio enhancing. And the program I use is a free program from Adobe called Audio Enhance. And so if I was to record a show, so you can't, it doesn't work live. You have to take the audio and you run it through the program, and it takes about 5 minutes and it enhances it. So if I was doing this as a recorded show right now, I would use that. Because what it does is you run it through there, and what you get is this great high quality sound. That's the enhancement. But it's an AI program that is listening to the audio and trying to, I don't want to say correct it, but trying to build on its interpretation of what is being said. So when I was doing a lot recording shows with Bill Noguera, who who is in prison, the audio on they use like a portable phone that they can place unlimited calls on, but they're only 15-minute calls, and then they have to call right back. The audio is terrible, and so the audio enhancer really didn't do well with it. So, for instance, when I would put the audio enhancer on those clips that I would make with Bill, the audio would come out so that me and Bill actually had a lisp, like a very pronounced lisp. It was distorted, and sometimes words were off to the point of being changed. It's not deliberate. It's just the AI doing the best it can with very poor quality audio. Well, that's going to be the case here. So when you're enhancing, I don't know what they use to enhance it. They may have used Audio Enhance. That's the only free one that I know of that's really good like that. But you could run that program 10 times, and it's going to get slightly 10 different results. It's going to get 10 results that are each slightly different. This is why it's not admissible in court. Now, even what we heard there in those clips was problematic, because it wasn't at all clear. And we human beings are very, very vulnerable to the power of suggestion. So if you're told that John's wounds on his right arm are the result of a dog attack, and then you look at the photo, you're much more likely to see dog wounds on that photo, because you've already had that idea planted in your head. So the human brain is a pattern recognition machine. That's what it does 24 hours a day. You're looking at that apple on the counter, and the brain is matching that image to known images on file of apples until it comes up with a match. But it's very easy to trick the brain. Very, very easy to trick the brain. This has been extremely well documented in science and by magicians, especially magicians that like to do science-based tricks. You can find them all over YouTube. So the power of suggestion really influences what we hear or what we see. And once we hear it, we can't unhear it. So once we're told that that's Kaen making a similar suggestion to how long could someone die in the cold, or how long could someone last in the cold, we can't unhear it. And there's no way to hear that again with fresh eyes. But when I listen to it, I don't really know what I'm hearing. I hear something that could sound like the word cold. The rest of it, I don't know. It's very badly edited and pasted together and stuff like that. And another question would be this: if there was something so those were made public during the trial a year ago, why are we just hearing about it now? Did someone just discover this now? So the whole thing is a little suspicious to me again, but I'm not at all saying someone deliberately did something. But you could run it through that enhancer a bunch of times and then eventually get one that sounds close to what you want. And you could also, the audio file that you produce from the enhanced file, you can run it through again and again and again. So you're getting something that's enhanced and then other enhanced, and you're getting further and further away from what was actually recorded. You're getting something that's very distorted. So my mind is open to it, but at this point, it's kind of a dead end to me. I don't consider it to be conclusive anything. I'd be curious to see what Jen McCabe says. I don't know what she said. Is that something that would be consistent with her memory I thought she had testified that Kaen had said this in the squad car, but it's also possible that Kaen was saying this in the squad car, but also was saying it when she was outside the squad car too, because we know she said it later on to the paramedic on the ambulance. So it was something that she was repeating and it was on her mind. So, but for me, I just don't factor it. To me, it's a nothing burger. And I guess if it's true, it would help substantiate Jen's claim that Kaen asked her that. But for me, that claim is already fully substantiated anyways. So it's not really, it wouldn't be proof of guilt anyways. It would just be proof that Kaen asked that question. So I don't really consider it to be all that important. Now, I got an article here that I want to go over with you guys. This is from Anonymous Mass Lawyer. And this really hit my sweet spot because this is something that I've been talking about in the book, but also in particular the last couple of weeks. And this is the question of what is reasonable doubt? What is unreasonable doubt? And because this has bothered me because every time I go on court TV or every time I'm watching it, I hear these lawyers, they look at every little thing and say, that's reasonable doubt, isn't it? And so you've heard me talk about it on the channel. It's like, no, you have to look at the totality of the evidence. You can't just find some little. So let's say there's a 10% chance that Karen's taillight was not missing pieces in the driveway at 5:08 when she pulls out. Reasonable doubt, they shout. No, because you have the 822 dash cam video. You have the tow truck video. You have Karen's description of the taillight when she pulled a piece out, when she was looking at it with Jen and Kate and Carrie and Kaen, that we've heard that audio in court. The jury's heard that. There's so much evidence there. So you cannot take an isolated piece there. And just because it's not 100% convincing and say reasonable doubt, that's unreasonable doubt. And so Anonymous Mass Lawyer took this on. I want to, when Margaret's on in a little bit, talk about this a little bit with her too. But this is a chance to maybe read that article in depth. And instead of wasting her time with that, I want to get Margaret more talking than having to listen to me read an article. All right. So an Anonymous Mass Lawyer, we communicate privately too. I don't know who he is. He's or she. They're still completely anonymous to me. But we're on the same page of most of these things. He's a little bit open to a theory that I'm not so much opening to, that Kaen, that there was only one cocktail glass, and Kaen brought it with her. And there was some complicated scenario where she threw the glass at, I don't know exactly what happened, at John, and it broke, and he was picking it up, and then it ended up being struck by the car while he was picking it up. To me, John's pretty intoxicated. He's not worried about a broken glass on the street, and it's adding unnecessary complications. But I like that people like me and Kate, or me and Anonymous, do have differences, because really it's in those differences that you get the most productive insights and the most productive work. So me and Kate agree with 97% of this case. And that's, there are differences, and the differences come out not just when we're on the air, but on the phone, because we had a great conversation on the phone the other day that, I wish it could have been recorded, and we could have just used it, because it'd be useful for the second book. But we have those conversations all the time. But the interesting parts come where we have a difference. And so, because she's listening to me and I'm listening to her, and we're processing, and you're wondering. And so I'm not unmovable on anything. And look, I started out thinking maybe there was a conspiracy here. So I am living proof that I move my positions. So based on the latest evidence, the strongest argument, the best logic, I will move my opinions. So, and Kate is about as smart as anybody I know. So these to me are really interesting and productive conversations, and it's because we have those areas that we differ. So same with Anonymous Mass Lawyer. So let's get to his article. Do you want me to pull it on the screen? I'm pulling it on the screen for you guys. Better look at that than me. So again, thank you for being here. So didn't finish my thank yous. Thank you to obviously Tom and Joe. Thank you to the partners who have kept us all afloat here and kept us all together as I was going through my medical situations. So particularly Kate, but obviously Matt, Jen, and Boomer, who a new addition to the lineup, does a great job, has a great voice, is interesting. He's the calm in the storm. Drunken Turkeys, I don't think has been on, but it's been a great cast. And tomorrow night, we're going to have a panel on at 5. This was actually Tuesday Gazette's idea. She reached out to me and said, could we do like a panel? And the focus, what she wants to talk about is the absurd theories in the Karen Read case. So we're going to go with that. And Jen Coffernaffer will be on, and Red Sky, our YCT legal counsel. And we're going to talk about different things. Some of the things we're going to talk about today, too, with Margaret, including will the defense call on Proctor, Higgens, and Brian Albert, things like that. So we have a good mix tomorrow. And anybody else of our regular lineup, I will extend them the invites. So maybe we'll see Kate, maybe we'll see Matt, whoever wants to come on. But we want to hear from some new voices. We don't get to hear from Tuesday too often. It's been a while since she's been on my show. I read her articles. She's doing a great job recapping the trial. All right, so I got a few minutes before Margaret comes on. Let's go to this article. Anonymous mass lawyer. As we near the end of the prosecution's case in chief in the Karen Read case, we're starting to enter the debate in earnest over whether the Commonwealth has met its burden in proving her guilt beyond a reasonable doubt. One thing I've noticed in my engagement with the FKR crowd on Twitter is that very few of them seem to understand what this concept actually means and how it's supposed to be applied to by a jury. The two biggest misconceptions I see are, one, a lack of appreciation of what the term reasonable means, and two, a strange and mistaken belief that this standard somehow applies to individual facts or data points in a case, as opposed to the overall body of evidence presented. Now, that's the main point, and that's what I've been saying. You guys know that, but said by a lawyer, it comes with a lot more force, and Anonymous is very articulate. So let's start with the actual jury instruction in Massachusetts. So this is the jury instruction. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him or her. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is not on on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. Now, this gets down to language. So if the probability was 1,000,000,000 to 1, that's beyond a reasonable doubt. But it's language. A jury's not going to think in those terms, so they have to give them the right language. This is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. What the hell does that mean? Right? No one knows what it means. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Is that clear to you guys? It's not, and it never will be, and maybe it really can't be, because you can't put reasonable doubt into an algebraic formula. So it's the best that people have been able to come up to, and it's always going to be room. It's going to leave room for interpretation with each juror. And that's probably how it's supposed to be. So there are two parts. This is Anonymous continuing his writing now. There are two parts of this instruction that are worth emphasizing. First, and probably most importantly, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. The jury is supposed to apply this standard to each charge, not to the individual facts or issues. And that's a key distinction. It requires the jurors to compare and consider all of the evidence. To take a recent example, Dr. Wolf testified on Wednesday that he believed John O'Keefe's skull this is the neurologist the state brought in, that he believed John's skull fracture was caused by him falling back onto a hard, flat surface. He also testified that it was possible for someone to sustain this kind of injury merely from a slip and fall. Within FKR Twitter, many reacted to that testimony by suggesting that it alone created reasonable doubt because John could have slipped and fallen and sustained his fatal injuries. Consider this tweet from Kaen. He posts, "I don't understand the posts I'm seeing that say things like, wow, it's over for Karen Reed. Dr. Wolf put the nail in the coffin. I must be missing something from his testimony. Dr. Wolf was extremely likable and highly qualified. He gave his opinion, which was that John's head injury was a result of falling backwards. I don't think too many people thought otherwise." Well, that's not true. Turtle Boy has been saying for a year that he was whacked in the back of the head with a bat or something or a weight. I don't think so why are the slam dunk reactions? Wolf never once said the word car or vehicle. All right. Being struck by a vehicle, then falling backward might be possible. So is slipping on the ice and falling backward, getting in a fight and falling backward, having a dog attack you, also backward. And that's reasonable doubt, isn't it? So let's go. Let's go to the analysis by Anonymous. This is a classic example of how not to apply the reasonable doubt standard. Sure, if Dr. Wolf had been the only witness in the case, there would certainly be reasonable doubt as to whether John's death was the result of a car collision or an accident fall. But that is not how reasonable doubt works. The jury will ultimately need to consider his testimony within the context of all of the other evidence it has seen. That evidence includes, among other things, a debris field of taillight pieces from Karen's SUV found at the scene, microscopic taillight fragments found entangled in John's clothing, John's DNA and hair found in the back of the SUV, the digital data showing that the SUV was gunned in reverse mere seconds before John's phone recorded his last movement. And that's not taking into account Karen's statements or incriminating behavior. In order to conclude that it is reasonably possible that John's death was the result of an accidental slip and fall, you would have to entirely ignore all of this evidence, which, not coincidentally, is why the defense has never even suggested such a theory. It's obvious to any sentient human being that no one would go to the trouble of framing Karen to cover up an accidental slip and fall. That's a great point, right? Stepping away from the facts of this case for a moment, imagine a case where the victim is found to have died from a close-range gunshot wound to the temple, and the medical examiner was unable to rule out that the fatal wound was self-inflicted. If all the jury had to go on was the testimony of the medical examiner, there would clearly be reasonable doubt as to whether the person was murdered or was a self-inflicted wound. But if you add in the evidence proving that the defendant was at the scene at the time of the death, had gun residue on his hand, and was even holding the weapon minutes earlier, and was seen holding the weapon minutes earlier, the possibility of suicide no longer remains a basis for reasonable doubt. Now, this is a great, great example. And this is something that I don't mean to be mean, but free Karen Reed people are just utterly incapable of even having those thoughts. And not just free Karen Reed people, but many of the lawyers that I see on court TV. It's disturbing and frightening to me that these people are up there and they're incapable of doing that. Let me see if Margaret is here. Hey, Margaret, before I bring you in, I'm sure you can hear me. I'm just going to take another minute and finish this article, and then we'll bring you right in. So Anonymous continues. As I pointed out on Twitter, there is a strange tendency within the FKR world to evaluate each new piece of incriminating evidence in isolation without any reference to all the evidence that's already a part of the trial record. They offer alternative explanations for new evidence without bothering to reconcile those explanations with the rest of the evidentiary record. And this is the key. This is stunning. So the area where this evidentiary fallacy is repeated the most is with respect to crash reconstruction. They misrepresent ARCA and saying that nearly everyone said that nothing else matters if FKR can establish some doubt on the accident. So the FKR will insist that literally nothing else matters if the prosecution can't prove to a scientific certainty that the exact mechanics of the collision and precise way in which each of John's injuries was sustained. While I do anticipate that the prosecution will offer fairly compelling crash reconstruction testimony this time around, I fundamentally reject this premise. This is a really interesting discussion point, and we'll talk about this after with Margaret too. The prosecution does not have to establish beyond a reasonable doubt the exact way in which the collision occurred and produced John's various injuries. The prosecution's burden is to rule out any possible alternative. This is an interesting idea. To establish beyond a reasonable, in other words, to establish beyond a reasonable doubt that Karen Reed caused John's death via a vehicle collision in some form as opposed to some other cause of death. Now, as a practical matter, I don't think that the state has to explain every scratch, but they have to provide, knowing that the defense is going to have up a fairly credible doctor to say those are dog wounds. You better have some kind of, at least a reasonably convincing alternative explanation for those wounds. All right, and finishing up. In other words, if the prosecution can offer a plausible version of how the collision could have resulted in John's various injuries and can, through other evidence, reasonably rule out any other possibilities, such as altercation, slip and fall, that is enough to support a conviction. I think that's probably technically true, but I do, like I said, you have to explain the injuries. And this is why the FKR crowd's fixation on the specifics of the collision scenario is misplaced. The prosecution has done a very good job marshaling the various types of digital evidence to create a very precise timeline of events for the details. See my prior post. This is again anonymous. Thanks to that evidence, the jury can have a high degree of confidence that John was standing near the flagpole area just seconds before Karen's Lexus was gunned in reverse, and that his phone stopped moving moments later. They can also be confident that his phone remained by the flagpole for the remainder of the night in a pocket state, shielded from full exposure to the elements. There is also incredibly strong physical and circumstantial evidence pointing to a collision, taillight debris, blah, blah, blah. When you combine this evidence with Karen's statement and incriminating behavior, including how she found the body, it would be perfectly justifiable, even absent crash reconstruction testimony, for a jury to conclude that there is no reasonable alternative left on the table. I'm going to stop here just because I want to bring Margaret on. There's only a few paragraphs left, but you can go find this on Substack, Anonymous Mass Lawyer. But this is a key thing here. So, in terms of my analysis of the case, yes, this is what I eliminated all those other possibilities over the last couple of years, and that's how I concluded that this is what happened. But it may be it no doubt is a slightly higher standard for a jury that has the weight of sending someone to jail for 15 years or something like that, or possibly more. That's an enormous weight, and as a practical matter, they're going to want a pretty substantial and somewhat convincing story put forward by the state as to what happened. So let me go and bring in, this is Margaret McLean. Hi, Margaret, how are you?
I'm great. Hold on one second. Good to see you, Kevin.
Take your time. This is not court TV, so people.
Yeah, I'm more nervous.
People expect a degree of technical difficulties from Yellow Cottage Jails and all that stuff. So I almost might have to force you to do that.
I'm not in my normal office, so.
Oh yeah, you're at the Cape today.
I'm on the Cape today. There we go.
We'll keep it classified. Don't worry.
Keep it classified. Thanks for having me on, though. Can you hear me okay?
Yes, you sound great. And
okay, good.
People have probably seen Margaret on Court TV, but if you haven't, she is the newest regular in their lineup covering the Karen Read case. And Margaret and I so you guys will enjoy the fact that Margaret used to work as a prosecutor with Hank Brennan in Lawrence, Massachusetts. So me and Margaret have intersecting lives at a lot of points. I grew up in Lawrence, and she worked as a prosecutor in Lawrence. I lived in Charlestown in the early 90s. This was back at the height of the Whitey Bulger stuff and the bank robberies and all that stuff, the armored car heist. Margaret, it turns out, also lived there at the same time. So
yes.
We've tread some of the same weird paths.
I know. I probably cut you off at the bar somewhere.
Yeah, probably. I used to hang at a place called a neighborhood bar, but it was a clean place called Sullivan's near downtown. Yep. I mostly went in there when the Bruins were on because we didn't have Bruins on the cable and they had them on down there. I don't know if you're a Bruins fan at all, but
I am. Oh my God, are you kidding me? Yeah. Oh yeah, Bruins fan, all Boston all the way. Even though I grew up in upstate New York, I used to be a Yankees fan years ago. But
wow,
yeah, wow. I know. But then I switched. I saw the light.
I after 9/11, I stopped hating Yankees and Yankee fans.
Yeah.
I don't know. It's just like, I'm gonna hate these. These are my fellow countrymen. It's crazy. So which takes some of the fun out of it. Plus, we've won championships, which takes, in some kind of weird way, some of the hatred out too. We've won more than them since the turn of the century. So
since the turn of the century, yeah.
Have
we really? I haven't.
Yeah,
we've lost track.
We've won 4 or 5, I think, and I think maybe they've won 1.
Okay.
So We're kicking their ass now.
We are. Oh my God. Yeah. That's awesome.
Uh, so we're going to talk, obviously, as a former lawyer, and Margaret's also an author. She's written a book on the Whitey Bulger trial, and she has some fiction books. But we're going to, since I'm not a lawyer, I'm thrilled to have someone who I can lean on her past experience with that. And so we're going to have some questions about, for instance, will the defense bring on Proctor, in her opinion? Will they bring on Higgens and Albert? And some other legal type questions. And you can pose those in chat too. But before we get to those, let's talk about some of the other relevant experience here that people would be interested in. So tell us about your work experience with Hank Brennan as a prosecutor.
Well, actually, I didn't know him. He came to Lawrence after me. So we probably
Okay.
worked on some of the same files. I met Hank Brennan through the Whitey Bulger trial, but we both came out of Lawrence. We both were I was in that old district court way back in the day, cut my teeth. The best place to cut your teeth is a prosecutor. And we both agree with that. But Hank Brennan, and the best story I have about meeting Hank was I was doing a legal analysis during the Whitey trial because I was in court all day, but in the morning, before the courtroom would open, I was doing WGBH radio every morning. I would say, "Good morning, Bob." And Bob would say, "Good morning, Margaret." We'd talk about the trial. And he would always listen to it because the courtroom, I didn't think, opened until 8. He'd sit out in the parking lot. And one day I said, "Hank Brennan, sit down." And he was cross-examining, I don't remember, one of the mob guys.
Yeah.
And then he introduced himself. And he said, "Hi, yeah, I sat down, just so you know, I sat down." And from that day, we've been very good friends. So, yeah.
So tell us about him. What's a working relationship or anything, the insights that our audience would be, our audience is extremely interested in everything Hank Brennan. So anything you got.
Yeah. Well, from the Whitey Bulger trial, I noticed that he's just, obviously he's an amazing lawyer, but he has some, I thought he was able to form a connection with the jurors in particular, because I just noticed, they seem to really trust him. And I know that Bulger was obviously a big mobster, and he's not going to win that case, but he did present an excellent case, and his cross-examination style was just amazing. Some of the best cross-examination I've ever seen. So there's that connection he had, and I have a feeling he's going to have the same connection with this jury. In fact, he's even gotten better. He's streamlined this case, so it's not as convoluted and confusing as it was the last time. But outside of court, Hank is he's a family man. He's just very talented at playing the harmonica. If you guys, when the trial ends at some point, you got to go see his band. Just unbelievably talented person. And one of the things that I'll tell you about Whitey Bulger trial, and I thought this was really interesting, was the victims' families. We all got to know each other during that trial, and it's really interesting that the victims' families embraced Hank Brennan because he went after the government, obviously, but that's very unique. And we still get together. Believe it or not, Whitey Bulger victims' families, Hank Brennan, me, some people from the globe. So
you anticipated my next question. And so before I get to that question, so the book is available on Amazon. What is it called again? On the Whitey Bulger trial?
Yep, Whitey on trial. Secrets. What is the subtitle? Oh my God, Whitey on trial is basically it.
And if you go just to Amazon and look under Margaret McLean, you'll find it. Yeah.
Secrets, corruption, right? And a search for the truth is the subtitle. Isn't that terrible? It's been a while since I've written it, but it's very good. I'm a little bit more than halfway through it. I've just been so busy, but it does have that aspect to it of readability where under normal circumstances, it's difficult to put down. I read a lot of it in the hospital. So you kept me company on some tough nights. But so this is, that was an interesting case, and there's a little bit kind of a segue into this case on that because of the Fed involvement. But here's the case where, like you said, his defense team, Whitey Bulger's that is, really almost wasn't trying to get him acquitted, although possibly acquitted on some charges, I guess. But
there was kind of an alternative goal there that Whitey was on board with,
Right.
and the victims were on board with. So
Yeah.
talk a little
Yeah.
bit more about that, about how that affected how he tried the case.
Well, going after the government was the best way to try the case because at the time you had the um, top echelon and the FBI informants. You had Connolly, who was corrupt at the time. So if they went after the FBI and all the corruption going back to the late 1970s when they were trying to establish this this top secret informant program, and that's the way they sort of had this underlying theme throughout, that the government was corrupt. And of course jurors love to buy into the idea of a corrupt government, and quite frankly I'm a little worried about that in this case,
Mm,
because we do have a younger jury, and
mhm.
sometimes maybe with a younger jury they're more likely to be worried about, maybe a little worried about conspiracy theories,
Right.
or they may not trust the government and the police as much as we did back in our generation. Not that we're
Right.
that old, Kevin.
Right. And that presents a unique challenge to Hank, because
Yeah.
like people that always say, Proctor, reasonable doubt. He
Oh,
hated Karen. And I say, okay, I have a one-word answer. Timeline. Because
yes.
if you want to tell me that Proctor hated Karen Reed and was willing for some reason that we don't know to frame her, okay, I'm all ears, right? The problem is, and this is where I turned on this case a couple years ago, there was no time. Her Lexus was indisputably to match the taillight pieces to the crime scene hours later. And during the day, we always know where the Lexus was. It was either under video surveillance at John's house, or at her parents' house, or she was in it.
Yeah.
And then it was towed to the police station. But by the time it got to the police station, it was too late. So the timeline just simply doesn't allow for the planting of evidence. So it doesn't matter what Michael Proctor said in his text. You could find worse texts than that. You could
Oh
find him
yeah.
saying, boy, I'd like to see this woman go to jail. It wouldn't matter. He had no opportunity,
I
you
agree, and
know?
especially for planting that. I don't see how he could have planted that hair or any pieces of glass on the taillight at the Sally
Mhm.
port, right? I
Yeah.
mean, you'd have to have
It'd have
multiple
to be
law
it'd
enforcement.
have, yes,
Everybody would have to be
exactly.
involved in it. And I
Mhm.
think in Hank Brennan has sort of made that clear as to who was there at the time. If you see the questioning when
Right.
he's talking to some of those people that were present at the Sally port, and who else was there and who else was there.
Right,
So
right.
I
So
think it's a
talk about the
stretch.
challenge of that, of trying to bring that. This is something you had to do in your career. Talk
Yeah.
about the challenge of having to establish that with a jury through questions of witnesses. It's not like you're doing it, that Hank is doing a podcast and he can go up there and just lay out the evidence and explain it to a jury. He'll get his chance in the closing arguments, but at this point, you have to have won the case before. I would know if you agree with this, but when the prosecution rests their case, they have to have won. Now, there's a chance for the defense to come back and score some points and get back to reasonable doubt. But if you haven't established by the time you rest your case that Karen did it, you're in trouble.
Yes, that's correct. Um, yeah, so it's interesting because in this particular case, though, I think the closing arguments will be important. So that, it's very important for Brennan and the defense to tie all their arguments together. Like
Mm.
some of that data from Shannon Burgess might have been confusing to people, even though I thought he presented it fairly well and straightforward. The
I thought so,
confusion
yeah.
came with the cross examination, and that's what
Yeah.
Alessi intended to do, which
Mm.
was smart. But I think Hank needs to really tie it all together in that closing argument and tie in the judge's instructions on the law in the closing
Mm.
argument. So that's what we try to do is we know what Judge Cannone is going to be saying, and then you say, well, you will hear from Judge Cannone. She'll tell you this, and it
Mhm.
fits into how it fits into your theory of the case as a lawyer.
Do you think that Hank cleaned it up well enough on redirect on
Yes,
the
I
Burgess?
do.
Yeah.
Burgess, yes. I was impressed with that.
Mm.
So I was cringing a little too when about on the education thing. I'm like, "Oh my God. Hank
Yeah.
must have been dying. Like Hank must have gone home and thrown something." But I really liked the redirect. He it was very straightforward, and the guy said, "Yeah, I haven't updated my LinkedIn in, 10 years, and these are all the other certificates I have." And the CV that was handed in to the court and the defense did say that he was continuing to pursue his education or his
Right.
bachelor's degree. So that was cleared up for me. You know, it would have been one thing if the CV handed into the court was wrong. That would have been really
Mhm.
bad,
Right.
but it wasn't. So I thought it was. What do you think about that, Kevin? You think he
So I
cleared it
had,
up?
yes, I did, and I had kind of a unique take on this that I presented on Court TV. So I'd like to hear what you think about this too. And this is so to me, it ended up being a blunder by Alessi. Now we'll never know unless somebody from the jury talks about it. But just my perception of the way regular people on that jury are going to perceive this, if they understood just how crucial that data was and how damning it was, that showed to where the vehicle data showed to the second pretty much exactly what time the 3-point turn was, how that correlated with the phone data, and how it showed where John was struck just seconds before his phone last moved. So the jury, if they understood that, then that now isn't in this tennis match when the other side goes up, they're going to be looking for, okay, what say you, defendant? How are you going to create doubt about that evidence there? And Alessi, unless I missed something, made absolutely no effort to make any doubt in that. What he tried to go after was Burgess's credibility, and went on for 2 days about the improper, the resume thing, but even the improper date thing. Like that to me is embarrassing for the jury. Like a jury's looking at saying, wow, so the guy made a mistake on the date. That's completely fucking meaningless. That's irrelevant. And
Right.
so so if
still
I'm a juror,
sloppy.
if I'm a juror, I'm sitting there saying, if you're going to something meaningless, it's because you have to. It's because you can't attack the main point.
That's
And so
true.
to me, so to me, I thought it did damage to the defense with the jurors, especially if Hank cleaned it up, and he did.
That's great insight. You're right.
I don't know. Who
Excellent.
knows? I don't know if it's true.
No, I think you're right. I didn't think of it along those lines, but you're absolutely right. Yeah. Yeah.
I think of it not as a lawyer, but as just an old bartender who's stuck on a jury in Lawrence.
Yeah, but let me tell you something. That's what it's all about. You don't have to be a lawyer. You use your common sense, have an open mind, always keep an open mind to both sides. And I think that's the problem with this case. Some people are set, have their mind set on Karen's guilt or innocence, and that's it. But I try to keep an open mind and view it as a juror would possibly view it. I was a juror once in a federal trial, so that gave me a unique perspective as well.
Yeah, as a lawyer, especially. I've been a juror twice in Lawrence.
Oh my God.
Both times. Yeah.
I'm surprised you weren't on one of my trials, Kevin.
They were both civil cases, actually.
Oh, okay. Well, I did civil. I actually was a civil attorney as well. So.
Oh, okay. Yeah, it wasn't you though. I would remember.
Me. You would have
You're very memorable. You're very memorable, Margaret.
You're funny.
I don't know if you got to hear any of the article that I was discussing from anonymous masked lawyer. I don't know if you follow him. He does great articles, and me and him are kind of so simpatico that on our reporting, and that people have accused him of being me, and people have accused of me of being him, but it's not true. And because we just end up with similar points, but his are better articulated from a legal perspective because he's an actual lawyer, and I'm just an old Bloody Mary maker. But so the topic was unreasonable doubt, or what constitute reasonable doubt? Because I see this thing abused all the time on court TV and by lawyers, and it drives me crazy, where they seize on, particularly, Peter, I forget his name, seems like a nice guy.
Peter Ellikin.
But every little thing becomes reasonable doubt to him. And if you went by that, nobody would ever be convicted. And I believe that Anonymous laid it out pretty good, that you have to look at the totality of evidence. The example he used was someone who died of a gunshot wound, and the medical examiner couldn't determine beyond a reasonable doubt if it was self-inflicted or someone shot him. So if you looked just at that evidence in isolation, reasonable doubt.
Yes.
And that's what Peter would do. And that's what, but you can't do that. He gave the example. So if you also had this, the defendant was seen at the scene with a gun in his hand, had gun residue on his hand, and a variety of other evidence like that. So when you look at the totality of evidence, no, there's no reasonable doubt here. This is the guy that did it. But they don't make that step. They're looking at things in isolation. And that to me is what I call unreasonable doubt. What are your
Well,
thoughts on that?
that's true. Yes, and I agree. So Judge Canoni, there's very specific instructions at the end of the trial about
Yeah.
what reasonable doubt is. It's not beyond all possible doubt, and then
Right.
she'll also explain and do an instruction on circumstantial evidence. So the Commonwealth can build a case solely on circumstantial evidence, and that's
Right.
what he's doing here. It's the pieces of the puzzle that are adding up
Yeah.
from you take the I hit him, I hit him, I hit him, the admission, all the way to that timeline. And that's what he said he would do in his opening statement, is
Yeah.
using science, facts, and data to build the case. And
Mhm.
that's why it needed to be streamlined. Whereas as last time it was confusing. However, I seriously, I covered this for my podcast last year, and I thought it was going to be a not guilty, just based on I found a lot of reasonable doubt at the
Mhm.
time. I was like, oh, there's no
Yeah.
way. But
Right.
Lally, I mean, he was able to get a mistrial, which
Yeah.
was
He got eight
he
eight
yeah.
votes for guilty. Looks
Exactly.
like
So, I
so.
mean, think about it now that it's streamlined, and you've got this new data from Burgess, and you've got Dr. Wolf, who was also amazing with the brain surgeon. I loved
Mhm.
I loved when Alessi was examining him. He's like, "Well, you're not a forensic what do you say? You're not a forensic pathologist." "No, I'm a brain surgeon."
It's like
That was great.
it's like, what are you, a brain surgeon? Yeah.
I'm a brain surgeon. The way he said it, I put that in my podcast. I'm going to put it on my YouTube. But oh my
That
god,
was
I
great.
loved
Yeah.
it. Loved it.
That guy was very credible, but
Yeah.
intimidating. If I was at dinner with that guy, I'd be like on my best behavior.
Oh my god, he knows his stuff.
Yeah.
If I needed my brain operated on, I would go to him.
I'm thinking about it. No, I don't. Can you give me a little IQ boost, Doc? Um,
Exactly. Exactly. He's
so how do these things play out in terms of legal strategy? So just all the various things we're talking about, but just most recently, the unreasonable doubt, or how do you, that jury instruction, I actually read it out because
yeah.
I've had it in my book and Mass Lawyer had listed it. So I read it out a few minutes before you came on. It's probably the only way they can define it, but it's not clearly defined. Every person
No.
listening to that, I don't think that's going to be very clear to any juror as to what the hell that means. I'm not saying there's a better way to do it. Maybe it's deliberately left open to interpretation. So how do you, these things that we're talking about here, unreasonable doubt versus reasonable doubt, just even as a conceptual level, how is Hank going to get this across to a jury? What's a strategic,
You know, he's going to have to stress his that the evidence, the science, the facts, and the data just add up. So it's the defense that's going to be using the word reasonable doubt over and over and over and over. And Hank is just going to have to take those jurors through, like sort of serve it up to the jurors on a silver platter and say, here's the case. The evidence is in our
right,
favor. Almost like don't be swayed by red herrings and
right,
this possibility here. So I think that's what the jury will be looking for, a straightforward present, so they can go from point A to point Z and say, you know what, he's built a case here.
right.
And how he will it's interesting. I will have to think about how he was going to deal with reasonable doubt. He may just quote some of the jury instructions. Remember, it's not beyond all possible doubt, or maybe he won't even talk about it.
Yeah. It might be best not
That's what
to
I thought.
talk about that.
Yeah,
I
and
guess
just
it's
say, here's
just,
the case
yeah,
from point A to point B. And if you go back and listen to his opening statements, which I've done, as I go along, say, okay, did he prompt? So an attorney does not want to overpromise anything in their opening statements. So I always look for that. Are they
right.
overpromising?
That's what the defense
So
does, but yeah.
I know, and it's not good.
Yeah.
So and you'll see the way he laid out that opening statement, and his promises, he's coming through on all the promises he's made that I've seen, especially
Yeah.
in the last week was excellent.
I'm pleased with it. To people that follow my channel here, they know for over a year he's doing
Yeah.
what I've been begging the prosecution to do. And I'm sure he has no idea who I am, but
Oh, he
he
knows who
did it.
you are.
He touched on a lot of the things a jury. So for us, a lot of us, especially me, but have been following this case for a very long time. So all the fundamental elements of the case, what time John died and what kind of car Karen was driving, all that stuff, that all has to be mastered. We mastered that long time ago.
Yeah.
And then as you got deeper and deeper into the case, we've mastered all those facts.
Yes.
But for a jury, they're coming in theory, knowing next to nothing about the case. And so they're lost and they're trying to get the outlay of the land. And in the middle of that, trying to separate what's important from what isn't important. That's extremely difficult. And every human being is going to have a limited capacity to absorb those things. So you have to, in my view, keep it simple. And this is something you as a writer probably think about when you're given exposition in your fiction. Yeah. And I think about in terms of my fiction or in my screenplays. You want to give them just enough information that they can process at a time. And you want to do it in a way that ideally is in some kind of a narrative structure, because the reason narrative structure works is because it's familiar to us. It's built into the way our brains are hardwired. A story has a beginning, a middle where you struggle through, and then resolutions at the end, different narrative structures that we use. And if you overload the brain, you're not going to take anything from it. And Hank really seems to understand this. He's kept the narrative simple. And what I love the outside box thinking. What I see to me is original, and you can talk about this, is this thing where so let's say he puts a witness on the stand. He withholds some key information, some evidence, might even be something that a piece of a visual that he's going to present. He withholds it to redirect, knowing that he's going to get another chance at redirect based on those questions. And this is such an effective narrative technique because it allows you. So when you finish your point, if you have a streamlined point on direct, and then you want to create that emphasis that comes at the ending, now you get two chances to do that because you're going to get another chance on redirect. And you're not asking a jury to absorb so much on the original direct. Now they get to hear it, and then there's that little tennis back and forth. So you get the other side, what they say, and now you get kind of, we call it cleaning up, but it's more than cleaning up because he introduces some new elements to it. So talk about that.
Well, there's a danger to that though, because so if you, let's say you forget, you're a lawyer and you forget to mention something in your direct examination, and if the defense doesn't ask any questions, like the last trial, no questions were asked of Kerry Roberts, then you just don't have another chance to get it in. Plus, this direct examination is limited in scope to what was brought out on cross-examination. So if attorneys need to always be listening to the answers from both sides. That's why when I used to try a lot of cases, my legs would ache after from just being like sitting forward and listening. Yeah. Believe it or not, my legs listen, I guess. So the point is, if a good defense attorney will say, I'm going to limit my cross-examination here because I know Hank Brennan didn't mention this. Maybe he's waiting. So now I'm not going to go into that little realm, that little area. Right. So far, you have to be careful. But yeah, he probably knows, unless he's going to ask this, Jackson's going to ask this, Unetti. Right. So, but he is skilled, very, very skilled at listening to the witnesses' answers and then taking it from there. So Hank, on direct examination, he's able to guide that witness with baby steps and make the witness shine. He's very good at that.
So let's talk about the big question. Yes. Will the defense have, I guess we could treat these separately. Will the defense have Michael Proctor testify, assuming that the state does not call him, and it looks like they're not going to?
I don't think the state will call him, no. But yes, I do think the defense will call him. I do.
Could talk about that. Talk about the strategic thinking involved, because there's a lot of people saying they won't. So talk about, especially from a legal point of view, the different rules of questioning and.
Yeah. Well, here's the thing. I think they want to taint the jury as far as the government is concerned, and Proctor's the lead investigator, so you can get Proctor up on the stand and you can really delve into why he was fired. And you were fired because you were biased against our client. So they can really get into that. And if they can plant the seed that the government, the lead investigator, Proctor, who's a schmuck with his text messages, is biased toward their client, they might be able to turn a few of the jurors against the government, which is the Commonwealth, Hank Brennan.
So what are some of
So
the problems that people are referring to? Because I'm hearing a lot of people, even people in the courtroom, saying they're not going to
yeah.
call. I'm like,
Oh,
so
the
what is?
defense. Well,
Mhm.
here's the thing. So the other side of the argument would be, well, the jury already knows about the text messages with Proctor. They've heard that he's
Oh,
biased to
they
some
don't actually.
degree.
Those messages have not been introduced yet. They tried.
I thought yeah, like, they talked about him a little bit with
I don't think they may have
Buchanan,
referenced them, but they haven't actually gone over the messages yet.
not
They
over
tried
them
to,
specifically.
yeah, I think they tried
Um,
to get him through with Yuri Buchanan, but they weren't able to
Yeah,
introduce
okay,
him.
not so there you go right there. That's where I think they will call Proctor because I remember last year when I heard those messages for the first time, I'm like, "Oh my god." That's why I thought there would be a not guilty. So, I mean, I guess the danger in calling Proctor if you're the defense is the jury might be like, "All right, we know he's not a good cop. We know he's been fired. We're tired of listening about Proctor. We want to hear the facts. We Brennan gave us science data and facts, and we
Mhm,
want to hear it from you. We don't care about Proctor's dirty little texts and
mhm.
his, bad personality. So there's that danger as well. But I think I don't know. I personally think they probably will call him.
What are the different rules of questioning between cross and direct?
Okay. Well, direct examination, you ask open-ended questions like, where were you on September 8th? I don't know why I threw that
Right,
date out, but
right.
what was the weather like? That's an open-ended question.
Mhm,
So you're not allowed to ask questions that would require a yes answer. So, like,
right,
your 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 shirt is green. Yes. So it will elicit a yes or a no answer.
right,
So those are reserved for cross examination. That now here's the thing: if the defense calls Proctor as a witness in their case, they can ultimately ask the judge to declare him a hostile witness. Then the defense can use those questions. Um, it doesn't have to be all open-ended
So
questions.
what are the rules for that? So if Proctor says, okay, I'm going to obey the summons. I'm coming to testify. How do you turn him into a hostile witness?
You would ask the judge, like you would have to begin questioning Proctor, and if he's giving you a hard time at all or he's being evasive, you can
Okay.
request that the judge declare him hostile. However, I do think Canoni will give the defense some leeway to ask those types of questions.
Right. Right.
Um, leading
Okay.
leading que- I don't know why that wasn't coming out of my mouth. Leading questions, but that's basically what a leading question is. A question that will elicit a yes or yes answer. Usually,
Right.
you were
Right.
fired. It's a fact you were fired instead of what happened on such and such a date.
Right.
So she may give them a little bit of leeway. Now if they do call him, Hank Brennan can get up and rehabilitate him,
Right.
so he can he can cross-examine the witness,
Right.
so
Right.
he'll still have his chance. Yeah,
So
it'll be
let's take
interesting.
on, yeah. So let's take on Brian Higgins and Bryant Albert
Okay.
collectively, since they also shared the butt dials.
Yeah,
So
yeah.
what about are these guys going to be called?
Yes,
Okay.
I would say so. Think about it for a second. If we want to go with Albert first, right? Let's go with Brian Albert. The defense can ask him all sorts of questions. Well, what happened to the dog? Where's
Right.
Chloe? Right?
Right.
Why wasn't Chloe Bart? Well, first of all, ask him about his bedroom, right? Did the bedroom where he was, doesn't the bedroom face the yard where, basically the side of the house where John O'Keefe was found and you had all those emergency vehicles. So he'll ask him about that. And isn't it strange that this German Shepherd who was supposedly sleeping in their bedroom didn't wake up? I get it if the people didn't wake up because none of the other neighbors did, but it's kind of funny, don't you think, that a German Shepherd, a dog, wouldn't wake up? Their hearing is amazing. So they'll ask
I
questions
don't,
like
just
that.
because we have a couple of dogs and and they're the same breed and their
Yeah.
personalities are so different. What they
Yeah.
bark at, what they don't bark at, it's the difference is incredible and inexplicable. And so it has nothing. It's just every and so Jen McCabe would have been very familiar to that dog. So,
True. I mean,
you know,
I'm trying to play devil's advocate a little bit as to why they would call him. The other
right, right.
reason, what else they would do is they would get into the butt dials with Higgins.
Yeah.
They would get into the layout of the house, and don't you have a basement? And you have weights in the basement. So there
Right,
again, the strategy of the defense is to create this level of suspicion. Okay, this
yes,
guy's a Boston cop. Somebody's out in his lawn. Why didn't he go outside? He must have heard the
right,
emergency vehicles. So they're going to be creating all that type of, make it look like, ooh, something really wasn't right here. Something smells funny here. So
right,
that's why I definitely think Albert and the dog, and they'll try to get in that those scratches, they could be from a dog, because they'll call their dog expert as well. What else can they find on on Albert? Oh,
they
mm,
might go into his history. They'll of fighting or something like that. There's just not
yes,
a long
yes,
history there, but there's some old bar
yeah,
fight or something. They might go
yeah,
into the video that was always absurd to me, among many absurd things, but showing him and Brian Higgins hustling around in the bar.
yeah. That's
Um,
absurd.
you
I
know,
mean, that's to me, that's a waste of time.
there are some
Who cares?
discrepancies in his statements. There's
Yes,
discrepancies in every statement, but
right.
where, and even some discrepancies between him and his wife about where they were looking at the
Yeah.
photos of his son that's in the Marines and things like that.
Yep. Yep.
There's just little things like that that they
But
might.
the jury, the defense has to be careful with going into too much of that stuff. Like that, as far as I think they need to stick with the main things, that the butt dials, they would stick with the layout and the basement and the possibility that you can, they want to make it look like a body could have been dragged out of the back door of the basement and over to the corner of the yard. So they
Right,
need to stay focused, I think. And so who cares about this little picture here, which way they were facing and all that. But I think they're
right,
going to focus on were there barbells. Oh, and also the other thing they're going to probably bring out with Albert um, is it possible somebody could fall down and hit their head on the cement in the basement? Like was there a rug or not? I
yeah,
mean, I don't
yeah,
know.
yeah.
Because that's what Nick Rocco said the other night when he was on with me. He was trying to say, well, they're saying he fell on hard ground, but he could have fallen in the basement. So,
Even though his phone never went in the basement, this is the problem.
absolutely not. No.
To make any part of this theory work, you have to ignore several other parts of it and
Yeah.
wander completely down the road of absurdity.
Yeah.
But I do think it's possibly an effective defense strategy. Someone in chat just said, I don't know why people think jurors are idiots. Now, I don't think jurors are idiots, but
Oh
I don't think
no.
jurors are very good at weighing evidence. I don't think most people are very good at weighing evidence, including many lawyers that I'm seeing on TV.
Oh
So
yeah.
I just
Yeah.
you're just going to ignore. Look, this is back to the unreasonable doubt. Looking at something in isolation. So could John's injuries have been caused by something else? Okay, but to believe that, could it have been caused in the basement? You have to believe that everybody in the house is lying. You have to believe that the some that somehow he went in the house without his phone, and that his phone was found underneath him on the lawn near the flagpole, which is where Karen dropped him off and where the last known GPS coordinates were. There's just so many things here that you have to just utterly dismiss. But they're good at that. They're good at just putting everything out of focus and focusing on one thing, and then focusing. It's just I don't
You,
understand that way of thinking.
speaking of the phone and all that, you know what I think really hurts Karen, doing those interviews. And a lot of lawyers agree with me here. Why on earth she did those interviews? That was silly.
Mm,
Okay,
yeah.
one of the things she says now, she's saying she saw John go into the house, like go right in, and she was
Right.
waiting there, and she said, "Well, he didn't come out," and she got mad and left.
Right.
Okay. So how come the next morning when she's with Carrie Roberts and Jen McCabe, why does she jump out right at the flagpole area where they
Right.
found his body?
Right. And now we
If
saw
she
a clip
saw
where
him
she
go in the
said
house,
she
that kills her right
and
there.
even one of the clips Hank
Oops.
played last week, she seems to say, we found him where I dropped him off. Now, she did say roughly where I dropped him off, so I guess you could
No, it's
include
not
that. But I mean, she knew where she dropped him off.
right. But if she saw him go into the house,
It's a
who's to
lie.
say he would be over by the flagpole? How did he end up
Yeah.
over by the flagpole?
Right. Right.
and like, how would she know he was right there? Like, I get that line of thinking, but
Yeah.
she blew it by going on television in that
Yeah.
interview. She
Yeah.
completely blew it.
Yeah.
Right?
Yes, it remains a mystery. And so, why did her lawyers allow this? I think maybe because it was going to turn them into celebrities. And so, could that be a basis for ineffective counsel down the road? I don't know. She's waived all those rights so I don't know.
I don't
Um,
know.
so I mean,
I don't
it
know.
does seem to. Did they really think that they were going to win this first trial? And so they didn't. So whatever came out in the documentary was not going to affect things because it was after the first trial. Um, so you
Yeah,
mentioned
but
earlier, but
well, I was just gonna say, I mean, some of those interviews, didn't they take place after the trial?
they took place mostly during the trial, up to and during
Okay,
the trial.
yeah, some
Yeah,
of them, yeah, but you would think that they would talk to the film company and say, "Okay, we're willing to do this, but if we have to retry this case, it's not going to be played." I
they
mean,
never got
right?
that in writing.
Contractually,
No,
yeah, I would have contractually
yeah,
thought of that. I mean,
they
come
should have.
on, you
They
can't.
didn't. Yeah.
Yeah, I
And
don't know.
I played a role in so um, most of the people, the witnesses and investigators stuff had been signed up for the Netflix documentary. And this documentary, when I was filming with them, and actually when I first filmed them, I had no idea that they were the Karen Reed documentary. People that would call, I didn't even know it was Unsolved Mysteries. When people call me up, I always say the same thing. Are you willing to put truth over numbers? I don't ask what your opinion is on the case. But if you want to exploit this just to do conspiracy stuff, I'm not doing it with you. But if your integrity is such that you're going to put truth over numbers and you'll always pursue that, then I'm willing to just give you this side and let you do what you want with it. And so after the trial, we now knew there was going to be a second trial, this is when John's friends, John Walsh and Brendan Kaen and Kerry, his extra girlfriend, had decided
Yep.
they weren't going to just sit back and quietly
No.
trust the system. They were going to get
No.
involved now.
Yeah.
And they had not been signed up. So I talked to the Unsolved people and I said, if I could get them for you, would you be interested? Oh, yes, we want to get that side. And, but I knew that they were going to be suspicious, because I got to know John and he's a good guy. And they were like, why would they want to film with the Karen Reed people? Right. And I
Right.
said, I said, my sense of having filmed with them a couple of times and talking to them is that they are people of integrity. I said, but let me ask you this. If they could promise you to get the documentary out before the second trial, so you can get some balance to the narrative, would you be interested? And they said, yes, we'll do that. So then I took it to the Unsolved people and they had a meeting with their staff and got back the next day and they said, we'll do it. And there's nothing contractual. It's a handshake agreement. But to their credit, they did do everything they could to get this out. And just they're selling it to another distributor, in this case, Discovery ID and HBO, to get it out
Wow.
before the trial. And it came out before the trial. So that
Yeah.
was an interesting part of it.
Yeah, I'm glad you
Um,
got them to do it because it gave us all a perspective on who John was. I
right.
thought the former girlfriend was amazing, and of course, Mr. Kaen was great too.
Yeah, he's super articulate.
Yeah.
Hopefully I haven't seen as much of him lately. Hopefully we see more of him out there. But John is very articulate too. John,
Yes.
so, and then they're good people and they're very, very loyal friends. And when you talk to them in person, they have all the
Yeah.
personal stories about John growing up with him, going
I
to
know.
college with him and stuff like that. So, he just, no human being is perfect, but this, he sounded like a really
Yeah.
good guy that always was
He
there for his
did.
friends.
Yeah, and his family. I mean, not many single guys would step up like that. I mean, he
Yeah.
changed his whole job around.
Yeah.
He went to a desk job as a result of taking those two kids in. I mean, that's
Right.
something. That's
Right.
amazing. Yeah.
So
Oh,
are
Higgins.
there any, oh yeah, go ahead. I think you would already, but yeah, go on. You can continue on that.
Have I already said? Well, we talked about Brian Albert. I think they'll
Yeah.
call him.
All right. Yeah.
And
So let's go Higgins and let's also incorporate a third party culprit discussion in that.
oh boy, I think they'll call Higgins as well because I think I don't think there's much to the flirty texts. In fact, from a woman's perspective, I think they hurt Karen Reed more so than they would
Right.
hurt the Commonwealth's case. I just saw that as Karen is in a relationship. She's practically living with John, and here she is in hot pursuit of Higgins. She's the
Right.
one that texted
Initiated
him
it.
over and over
Yep.
and over. She initiated it.
Yeah.
And then I don't see I don't think he ghosted her at the end at all. I don't interpret it that way at all. Do you?
Mm. There's no way to know, but
No, there's no way to know, but just because he didn't respond to, or she
I
didn't
would I
respond,
would
or
I would say
she
he
ghosted him.
sounded.
That's what I meant.
I mean,
Yeah.
I don't think it's unreasonable to guess that he was still interested, and part of his reason even to go into that party might have been. But we don't know, and it's not really, to me,
Yeah, you
relevant or
can't.
pertinent to the facts of the case.
Right.
It certainly doesn't add up to a motive for murder.
I don't think it
You know,
does. I don't
and
think it does.
and
But I think they will call Higgins because you can get into the butt dials with him as well. Oh, the big thing about Higgins, why did you destroy your phone? Why did you throw the SIM card away? And you cut through this base and threw it in a dumpster. So again, they'll say that to Albert as well, like,
yeah,
and try to make it as suspicious as possible, that wow, there's something going on here to destroy the phone like that.
right,
And we also know there are many innocent reasons why someone would destroy their phone. It doesn't mean they're
right,
covering up a murder.
right. And in the case
Yeah.
of Brian Higgins, so you're on the Cape right now. So
Yeah.
I go to the Cape every year. I have a friend there, and his mom lives in Brewster. And so when Higgins was testifying last year, it just clicked into place for me. They don't have trash pickup on the Cape. You have private trash pickup. So either you pay for your private trash pickup, or you drop off your trash at the town recycling center. And so in the case with Brian Higgins, he has access to the base because of his military service. You're going to go through the base, get your cheap gas or whatever else you want to get there, and you're going to throw a couple of bags out. He lives by himself. He's not generating a lot of trash. And so if you're disposing of your phone, it's going to be in that trash. There's nothing suspicious about it. And the SIM card doesn't have texts on it. The SIM card just has like identifying identifying stuff, contacts and stuff like that. In his case, he does undercover work.
I know.
So his phones are updated pretty regularly, and
Yep.
once he destroys them, he has to destroy that identifying information. It's all
Yeah.
has a
And
mundane explanation,
exactly. And I think that when the defense calls him, because I think they will, I could be wrong, but when Hank has his opportunity to get up and question Higgins, he'll mention all that stuff. Like,
Yeah, yeah,
um, and also I thought Hank did a nice job as well on, how the whole Sally Port thing with the inverted camera, and how he said, well, the camera's always been mirrored like that.
yes,
That's
yes,
the way it's been. And people will, even so, if this is a younger jury, they'll understand that. Like me, when I do a YouTube video now, I have to make sure I mirror my camera, or Whitey on trial in the background comes out backwards.
yeah,
So they're
yeah,
gonna know that.
yeah,
It's very
yeah.
normal.
There's little tech things like that we don't think about,
No.
that are just normally going, that audio video people understand, that are normally going
Yeah,
on. And this is the thing
exactly.
with this case, is pretty much everything has either a very mundane explanation, or at least a reasonable, plausible explanation. All the strange things that were presented us on day one that look really strange. Why didn't the Alberts come out of the house? Eventually, once you wait for it, if you are actually interested in the truth, you'll get the explanations. So
Yeah.
one of the harder ones, though, so I didn't watch as much of it this week because it's one of the most boring testimony, was the glass testimony. I don't know if you had a
Oh
chance to
yeah.
watch that.
A
So I'd like to
little
talk
bit.
about that, because for me, last year, and when writing the book, I went and rewatched that testimony. Her name was Hanson, Merrimack College
Yep.
criminologist, and it's discussing how you match glass is really tedious. I even bought the only book on the subject. Oh God,
Oh God.
and I skimmed through
Good
it,
for
but it
you.
was but the reason I focused on it was because it was really the last remaining mystery, other than perhaps the Ring video. Um,
Yeah.
so again, I didn't watch it this time, but this is what I got from the take from last time. So you got basic three types of evidence with the glass. You have the cocktail glass remnant, which is found near John's body, which
Yes.
is indication that it was in his hand when he was struck, because it's going to have that
Yes.
same momentum, that same angular momentum, and it's going to go with him. Then you have on the lawn, 9 pieces of glass are found, and then you
Mhm.
have 6 pieces of glass that are found on the bumper. Now,
Yes.
of the pieces on the bumper, none of them are matched
To
to
the
the
cocktail
cocktail
glass.
glass.
Yeah.
However, one of them is matched to the pieces on the ground.
Yeah.
The 6 of the pieces on the ground are matched to the cocktail glass. So there is a match, but it's indirect. And then there are two pieces of the glass found in the bumper were consistent with, but not definitively matched. And then there were two that were not matched.
Yeah.
What, do you have any possible explanations of this?
You know, I thought that part was confusing.
Mm,
I think the jury is gonna find that kind of confusing. I mean, consistent with could mean it was still the same glass, right? But
right.
it doesn't I don't think it means quite as much. Oh, again, we have, oh my God, Karen killing herself yet again when she's the video that Hank very carefully puts that video in when necessary, so the little video of Karen picking
Mhm.
glass out of John's face. She
Right.
describes that.
Yeah.
So, she's killing herself. But
Yeah.
what's your thought on the glass on the bumper? What do you think? Do you think it's
I'm still, I don't want to say troubled, but I'd
yeah.
rather have a better explanation for it. So what I ended up concluding in the book was that likely all of those pieces belong to the cocktail glass.
Yeah.
And so but couldn't be proved. So the thing is it turns out matching glass is very difficult. They have a couple of machines they can use a little bit, like an infospectrometer or something like that, but they're pretty much useless. Useless. At the end of the day, what you need to do is physically match it like a 3D jigsaw puzzle. So this poor criminologist
Jesus.
has to take those pieces, look at them under the microscope, and decide which piece fits what other broken piece. Wow,
Yeah.
I thought I had a thankless job.
Jeez.
That's just hard to do, and there's going to be pieces, who knows how many that are still missing that are in the lawn there,
Yeah.
and so, and it's in terms of matching like type of glass. We falsely think that and this is documented in the book too, but one piece of cocktail glass is one thing, so it's going to be consistent throughout. No, if you actually look at a glass, I don't know what goes into making of it, but the lip is going to be very different. It might even
Yes,
have
I
a
was
gold
gonna ask
strip
you
around it.
that. Yeah. Yeah.
And the base of the glass is going to be they're different thicknesses. They may be different specs of things in them. I have no idea. This was not about the making of glass. The book I read, it was about forensics, so I don't know. So that a problem there where they're just not able to identify it because certain pieces of the glass look different than other pieces. But a final thought I just had this in the car yesterday driving to Boston, and so
The
I'm
light
wondering.
bulb went off.
Yeah, a broken one. uh, but this may be crazy, so I'd be curious to what you think. And if there's any truth to this, Hank could have in theory tested this. But if I went out to the car now and forensically examined the back of the bumper, what would I find on there? Would I find possibly tiny pieces of glass? I mean, your car is on the road all the time, picking up all kinds of stuff off the highway. Would I find little pebbles there? Is it smooth and clean? I don't know the answer to that. So is it
Well, I was going to do a little experiment with my car, okay, and I was going to put some glass on and see how long it lasted, but
Oh,
then I didn't do it because my car, the one I have now, it's smooth, but her car had the ridges, like in the back. If you really look at
okay.
her bumper like that, so. And if you look at the picture from when it was on that flatbed, there's
Yeah.
if you're towed on a flatbed with the aerodynamics, it's not going to be. I think that the glass could have easily stayed on, and it was underneath the compact ice that
Right.
was on top of that. So
Yeah, I had no problem with believing the
I have
glass
no
would stay on
problem
the
with that
car.
at all. It
My
wasn't
problem is
planted.
explaining
Yeah,
the mysterious glass.
I know, I know. Yeah, you could argue that, but what about recycled glass? What if this was made with recycled glass? Wouldn't that be hard to match it up? I don't know. See, you read the
Yeah, I
book on
know.
the glass, not me.
As much as I could.
Yeah, but I
Um,
don't think it means that much. It's neither here nor there. It's not definitive.
right.
So
That's
they'll
the
probably
other thing.
just jury
The
will probably
state could
just
do
dismiss that evidence, like, or
right,
say, well,
right.
whatever.
That's it. The state could do without this evidence. They're just
Yeah,
being honest with the jurors and being fair to both sides and presenting it. This
right.
evidence is in
Exactly.
no way essential to their thing. And so my experience from reading true crime, and I'm not obsessed with true crime, so I'm not I'm not an encyclopedia of true crime cases, but when I do dig into when I try to read deeply into the case, and it seems to me in every single case, and this applies to things, obviously big conspiracy theories like 9/11 and JFK and stuff, there are always a certain amount of things that are unexplained, and that's just nature of the beast.
Yeah,
And
yeah.
if they're not essential to the case, to the case for or against, that maybe you just have to kind of accept that there's always going to be something in there like that. Is that, I don't know, is that reasonable or?
Yeah, and of course, remember, it's the defense that their job is to create as much reasonable doubt as they can. A little bit of
Right.
reasonable doubt here, and they'll say at the end that it's all adding up. There's so much reasonable doubt in this case, and they're better off using the reasonable doubt method than trying to prove a conspiracy.
So let me
A lot
ask
of
one last.
Yep.
What
Oh,
I'm going to
take
ask one. I'm going to ask one last question, and then we can go to questions in chat. Or you, if you there's anything you want to bring up or ask me, or anything you want to discuss. So my last question would be this: go back to when you first started looking into this case. What made it interesting to you? What were your early thoughts? When did you first become interested?
Well, I was actually podcasting on the Anna Walsh case, the missing woman out of Cohasset,
Mhm.
because that's
Yeah,
really right next door to where I live. So I was
yeah,
obsessed with that, and the media was obsessed with that. And then I happen to have friends who live in Canton, and they would say, "Oh, the real case is this Karen Reed case," and so that's how I first heard about it. I'm like, "Oh yeah, yeah,
yeah.
yeah." So I dismissed my friends, but then I started to really look into it, and it was amazing. So, then I followed the case last year on my podcast, and that's how I really
Mhm.
got into it. But how did you find out about it first?
So people started texting me the morning when Turtle Boy first
Yeah.
put this out there on April 18th of 2023.
Yep.
And so I knew what I was looking at was not the result of a journalistic investigation, but that a defendant had fed him that. Anybody of common sense could see that, I would think. Well, that
Hmm.
explains mostly his audience. Um, but being a total noob when it comes to things like what did I know about forensic data, right? To me, data was just data. So it was presented as though that 227 search was something that was found late in the game, but was not in dispute. And so I'm like, if Jen made that search at 227, yes,
Oh
there's
yeah.
something foul that happened here. And
Yeah.
there's no way she's innocently making that, just coincidentally making that search. But then we learned
Right.
maybe in June at a hearing that Adam Lally said the state has an independent expert who we now know is Jessica Hyde, and she
Hmm.
has a different explanation in that it didn't take place then. So now I'm like, okay, now we're back on the fence. That's 50-50 on that issue there. And if you take 227 off the table, you got to keep digging into the rest of this. Does it make sense?
Right.
How did John's phone end up under his body on the loan last having moved at 12:32 and 16 seconds? Does it make sense? And I was asking these questions early, but does it make sense that the killers are going to move someone alive, keeping him alive, onto their own lawn, move him a little further, he's on the street, and you can more plausibly say hit and run.
Well, actually, if you really wanted to get rid of, if there was a fight and he somehow got incapacitated, right? He wasn't dead yet. Let's say he's half dead, almost there, and they panic. Well, aren't there railroad tracks back to
Yes.
somewhere back behind the property? Just throw him on that and say, "Oh, he must have been drunk and he got
Yeah.
hit by the train." I
Right.
mean, come on, these are
Right.
investigators.
Yeah.
They're not.
If anybody could plan a conspiracy, it should be these cops, right?
Yeah, and also, let's say hypothetically there was a fight and he fell backward and hit his head, and right? They could always say, "Well, he went after us first. This was self-defense. He was jealous of, Higgins, whatever." They could have come up with something like that, and that
Right.
would have worked.
Right.
It
Just
just it
to
just
just to
doesn't
res-
make sense.
just
Yeah.
to respond to Jose, he says, "What
Oh,
makes you
let me
believe they
see.
call Higgins?" But we never said that the state was going to call Higgins. So I think you've mixed up what
Oh.
we've said. It's apparent to us that the state is not going to call
Oh,
Higgins.
yeah, yeah. I
The question
I
was whether
agree.
defense
Mhm.
that was whether def- and I, by the way, I agree 100% with
Yeah.
Margaret on her analysis and that, but I'm not a lawyer, and the buzz seems to be almost at this point conventional wisdom that the defense is not going to call on these people. So I'm just curious as to why. I'm getting
I
this from
agree.
a lot of
Ye
people.
Yeah, and I agree that the Commonwealth will not call Higgins, the Commonwealth will not call Albert or Proctor, but that's
Right.
gonna be the defense, and I'd be surprised if they didn't based on what we talked about. But that's a good point, though. Good point in the chat.
So
Um,
Irene asks, wouldn't the state be better off calling Proctor?
well, Some people say yes, because get the bad stuff out first. However, ugh, I don't know. I wouldn't. I know Hank's not going to call him at this point, because if he were to call Proctor, it would have been sort of somewhere in the middle. Not like this is. I think this might be the last week for Hank's case in chief. So he's not
Mhm.
going to want to call him at the end, and everybody's
Right.
going to be stuck
Right.
with Proctor. But
Right.
that's a very good point, and many lawyers have debated that.
Right.
I personally would not want anything to do with calling Proctor.
Right. Right. And that's the
Ugh.
approach that Lowy took last year, was to get out ahead of these things. And he spent most of his
Yes.
time, but
Poor Lally.
so this question here, you may not know about this. I'll talk about it a little bit because Karen has even now talked about it. But for a long time, we have from multiple good sources. But again, yeah, I don't usually talk about it because things can get taken out of context. But supposedly it was seen perhaps by Proctor or somebody else on the phone before it went to the taint team, that Karen had texted her lawyer that afternoon, David Yannetti, when they were first making contact. I didn't think I hit him that hard. Now, I'm very careful with this stuff because that would be attorney-client privilege. But not only that, it's unfair because we may be losing context of what, and if she may have said something similar, but not that, which can be very different. But I think this is what they're referring to here, is if because I have heard people say this, that if the defense calls Michael Proctor, that they'll find some way to introduce, he will find some way to slip that in. And I believe that's not true. I believe that would be reversible error. But what do you think?
Yeah, I don't think that they'll be able to put that in. But Proctor's also a wild card right now. He has nothing to lose. Maybe he doesn't
Yeah.
even care about helping
Right.
the Commonwealth's case. I don't know. Unless he
I
hates,
don't know.
at this point, maybe he probably despises Karen Reed at this point, I can imagine. And he's got to be
Yeah.
bitter. So that's
Oh,
another
yeah.
thing that's come up with my discussions, with various attorneys. We think, well, he's just such a wild card, and, ugh.
I
What
had
a
another
shame.
question.
And this case just blew up with all sorts of stuff like that. Let's see, what's the next I have to put my glasses on.
All right. That one's already in there. Let me go back a little further. There was a good question that I wanted to get, and I can always save one at a time, and then it scrolls in
Yeah.
the chat. Someone said, couldn't Proctor plead the fifth? I don't understand that. He's not charged with a crime here, so I don't.
He's
He
not
did. He did.
charged with a crime. No.
He's not. There's not
So
even a potential crime. I mean, he didn't.
not that I see, no.
I mean, unless
So
they
he
think he
can't plead the
planted
fifth.
evidence or something, but I mean, he
Yeah.
didn't plant evidence, so
It's a good question,
uh,
though.
yeah.
It's a great question.
I can't find the question. It's so hard. Scrolling through chat is difficult on this format. I know you're just switching to StreamYard, and no format's perfect, but here's
Well,
a good
I
question. Here it
like
is.
this.
So, Top Cat says, "Does Margaret think the state has enough evidence to prove murder too?"
Well,
That's a good one.
I do. So here's the thing that I like to explain. Murder 2 is not murder 1, meaning you don't have to say, oh, I had the intent to kill, right? It's
Right.
all about the act. So what Hank has to get to the jury beyond a reasonable doubt is the elements, and that would mean, for this particular, what he's going for, and if you go back to his opening statement,
Mhm.
Karen was behind the wheel. Okay. She had just dropped John off. She knew he was standing there, right? So
Mhm.
she
Yeah.
pulls her car up, and, quite a distance, and then
Mhm.
backs up at a dangerous rate of speed, 24
Right.
miles an hour. That's fast to back up, knowing he's standing there. So it's the act. And it's an act above the recklessness standard. So it's
Right.
such an act that she knows by completing that act that there's a good chance she could kill him. That's
Right.
your second degree.
And
Now
this
you're
is the
in.
third. This is the third prong of second degree, right? The kind of
Yes,
reckless
yes. So
endangerment
there's
thing.
other, right. But it's above a recklessness standard. It's and that might be hard for the jury. So sometimes what happens is, the district attorney will charge second degree involuntary manslaughter, and then maybe leaving the scene, as they did here, so that the
Mhm.
jurors, if they're debating on second degree, well, we're not so sure about second degree, but we'll convict her on involuntary manslaughter. And I think you've got a better chance at that, because with the manslaughter OUI, all they have to see is she intoxicated at least to a 0.08, right? She's behind the wheel. We know she had 9 drinks, and that's a recklessness standard. So she's backing up at a reckless, very reckless driving, right? It's it's just the act. She might not have intended to kill him, but it's the act of driving while you're drunk. If I'm drinking now while we're doing this podcast, which I'm not, or this YouTube, I went out and I
stick with me long enough, I'll
hit
drive
somebody. Yeah, if I went out and drank one of your Bloody Marys and I went out and hit somebody, that's homicide. That's vehicular homicide.
And that's so I talked to a retired judge, Carol Erskine, and she on the phone, and she's going to come on eventually. She's got a book out about Harmony. I forget her last name, the little girl. It's in the news a lot. That, but she said, as a practical matter, the third prong is difficult to get second-degree conviction on. The jury's looking for more substantial intent involved. And what I wonder where Hank seems to be going on that is where I always thought it made sense. And what is this, Margaret? The fact that at some point Kaen knew that John was hurt, John was potentially alive, and she never called 911.
That's harder to prove, but yeah, he did mention.
For example, at 5 a.m., Kaen calls John. Kaen calls Kerry Roberts. She's taking a nap.
Dead.
She woke up about 4:30, and she says he's dead, maybe hit by a plow. So she seemed to have put something together there, but she never called 911.
I know.
So is that the strat? Is that where Hank is aiming? Is it?
I think it's the act. If you go back and listen to that particular part of his opening statement, which is towards the end, and I would recommend anybody interested in the case, go back and watch that. You don't have to go through all the beginning stuff, but it's towards the end, and he explains. I think he's going for the act. You'll see, because I think the other is, I mean, they can consider it, but I think it's more of a stretch. If he can convince them that, hey, it's all about her getting in the car, and like he even mentioned pressing her foot on the throttle up to 75. What was it? 75%.
70%. Yeah.
70%.
For like 4
and then,
4 seconds.
And then the speed. Yes. And then he explained the wheels of the Lexus were spinning. And so, and she also, another thing that goes into the act is she knows it's snowing out, and it makes it even more dangerous. So if I go speeding up, if you're standing there, Kevin, and it's in a snowstorm, and I know you're there, and I'm going to back up in your direction going 24 miles an hour, that's a dangerous act, and I could kill you.
Yeah.
And I know that I can kill you. And again, it goes to the reasonableness standard, right? Does a reasonable person know that that's a dangerous act? I get somebody killed. Gee, she almost killed me.
Funny Bunny says the temperature of the phone was great. What if they showed?
Oh, that was great. Let me see my glasses again.
How quicker the temp would have gone down if it was not under the body. Well, it's too late to show that stuff now, I think, unless Dr. Welcher brings it up in his. Dr. Welch is going to bring all this stuff together.
Yes. I'm going to put it together. That's going to be a big one.
Yeah, that's the key. That's the key witness. And hopefully there's nothing that's been missed that will allow them to poke more holes into his credibility, because Aperture's taken some dings at this point based on the resume stuff. This may not be the things that we in the public think it was, because some of this stuff was not intentional, just automatic resume updating and stuff like that. But nonetheless, they are dings in front of a jury to their credibility. So,
I was just like, you got to be kidding me when I read that. All right, when I watched it, I mean, let's see my glasses. I got to get some better looking glasses. These are old.
This is. You probably don't know who Scanlon is. That's knee deep into this. He's covered in the book, but he is kind of at ground zero with a lot of this. But I don't believe the prosecution will be calling Scanlon up. He doesn't have, or the prosecution definitely won't be, and I don't believe that the defense will either, because he doesn't have anything. Scanlon's a private investigator that reached maybe in some ways the start of the conspiracy theory. He had he picked up scuttlebutt in the days before Kaen was arrested. So in the few days after John's death, and that scuttlebutt was that John had been attacked inside the house. Now Scanlon had been old friends or acquaintances that with Brian Albert. He'd been in the house before. So he doesn't really want this out because he kind of betrayed a buddy to go and insert himself into this. So he reached out to Kaen over Facebook and whatever he said something, something to the effect, I don't know. It made her say, well, reach out to my lawyer. So he called Yannetti the morning of Karen's arraignment and basically said, I have information or something to that effect, and gave a false name. So on the way, so when Kaen went to when Kaen met Yannetti, Kaen was arrested on Tuesday, spent the night in bars. The arraignment was Wednesday. She met David Yannetti for the first time through the prison bars. When they went over the case, they were handed the charging documents. And at that point, there's no way that Kaen or David Yannetti believed she was factually innocent, because when they went to court an hour later, he did not stand before the judge and say, my client is factually innocent and she looks forward to the day in court. No, what he said was, my client had no criminal intent. She loved this man. If there was even any idea that they might say that, they would have said my client is innocent, just as a default, right?
He didn't. He made the statement that it was an accident. There was nothing more than
he said it
accident.
exactly. So on the way, according to what he reported to Gretchen Voss in her article in Boston Magazine, it was on the way home that he returned that call to what turned out to be Scanlon. And that's when Scanlon told him, I believe that John was killed inside the house, and it involved a federal agent and the nephew. This is the story that Yannetti has told now, anyways. And then he had Scanlon meet in Yannetti's office with their private investigator, former Medford cop, Paul Mikowski. And they discussed a range of issues that are all along these familiar conspiracy lines now. So I believe the conspiracy theory actually formed organically on the ground, nothing to do with Kaen and nothing to do with her lawyers. You had the circumstances here that were ripe for an urban legend. You have a cop is found dead on the lawn of another cop where he'd been dropped off for an after-hours party. He looks like he's been beat up. His eyes are all swollen. That word about that would have been going through town. And at this point, Kaen hadn't even arrested yet, so I'm not even sure if she was in those early days part of those discussions. But I just think that and other elements there, people's natural mistrust of the police, knowing that a federal cop might in there, they're just going to start fueling these kind of fantasies, urban legend stuff that eventually morphed into the conspiracy theory.
And then the Google search and everybody, as you mentioned earlier, everybody
that wasn't known then.
That wasn't known in,
like
but then when it was known, it's like nobody knew that that's what we do, is we often search in open tabs. Like I learned something. Yeah. I didn't know about that stuff. But you're right. You're right.
I'll take one or two more questions. And is there anything else you want to go into?
Me?
You want to talk about any of your ongoing work or future work?
I think I would like, I've been thinking about that, the whole thing that happened with the jury, and that's kind of interesting. What are your thoughts on that? In court, how it's I'm telling you as a lawyer, it's very unusual to call all 18 people up individually to be questioned, and then to have jurors change seats. That's weird. Why not just kick them off if they're talking about the case?
This jury is being watched incredibly closely, and for good reason, because of what happened not obviously the basic reason of what's going on with this hysteria, but what went on in the last trial. And I've talked to several people on the ground that know the whole story, which I don't want to reveal all of it, but I've revealed a lot of it on this channel, with the juror that was dismissed, the second juror. And that juror was also had a direct role in the dismissing of the first juror. This juror got on there that seems to have been a Karen Reed juror that slipped through the cracks. And she, and the first juror that was dismissed, she sent a note to the judge saying that this juror is saying bad things about Karen or something like that, or making bad faces. And so the judge did a voir dire of the juror that was accused of that. She denied it, but she still, on an abundance of caution, threw that juror off and talked to the people next to that juror. So that's for that trial. So this was the first trial. And so that the judge interviewed 4 of the jurors. Now, the juror who made the accusation also told the judge that the other two jurors would corroborate what she was saying, that this juror was saying, making faces or saying stuff about Karen. However, when the judge spoke to him, and this came out in documents about the sidebar a few months ago, when the judge spoke to them, those people said, no, we only know that person, the one that's making the accusation, was telling us that we never actually saw the juror or heard the juror do anything. but
Okay.
still on the so this person managed to get somebody thrown off the jury. Well, then now I know for a fact that around that time she went out drinking, this juror, and was going into bars in Dedham drunk and saying, "I'm a juror. I'm free Karen Reed." Supposedly she even said, I'm a turtle rider and I'm going to acquit Karen. Well, she got away with it the first time. I don't know exactly how many times she did it. I talked to people, but the second time was the night before she was dismissed, which was very near the end of the trial.
Jeez.
And there's a whole long sordid story of what happened, but similar idea. And so some version of that, some small version, reached Judge Canoni. I don't know what. And as a result, she was dismissed. And she's been in close touch with Turtle Boy ever since.
Ugh,
So
gosh.
this to me was a strategy of this case. It's not an acquittal strategy of the defense team. It's always been a hung jury strategy, pollute the jury pool and get one or two diehards that just are willing to, whether it's nullification or something else, where they're willing to kind of lie under oath, lie every day when they say, "Have you followed this in the media or discussed the case?" When clearly they have.
Yeah.
So this is what Hank, this is the challenge. He can present the perfect case and have the
I
perfect
know.
evidence and still face a hung jury.
You never know what a jury
No.
will do, no matter
Yeah.
what. You just don't. And the the other thing, statistically, when they do retry a case, excuse me, and it's a hung jury the first time. Statistically, the prosecution ends up winning. Not all
Right.
the time. But
Because if the truth is on your side, and I would say there's plenty of false prosecutions in the country. The
oh
the
yeah,
prisons are full of people that are falsely convicted. But nonetheless, it wouldn't make sense to have a system for them. They're swamped with cases to be trying to, put innocent people into jail all the time. So most of the people are probably guilty. So if you have the facts, if you have the truth on your side, the more time you have, the better and better your performance is going to get. So it's definitely going to be to the advantage of the prosecution. And so here's a question from James Hamlet, and I'll expand on his question a little bit. So the question is, Kevin and guests, what more can the prosecution provide minus a video of the vehicle strike? So expand on that to say what more they can provide, or what you think they can do better. Is there anything that you think they could be doing better? The
well,
prosecution.
we're going to see. Right, we'll see this week what
Right.
he has as far as when Welcher gets on the stand.
True.
I think he's done an excellent job. The best part, really was Shannon Burgess with just matching up that cell phone with the Lexus down to the second.
Yes.
But now they can show how fast the car was going, 24 miles an hour. That hasn't been
Yeah.
put into evidence yet. They can show. They'll probably streamline it from the last time.
Yeah.
What do you think, Kevin?
So
Going
that you
effective?
mentioned that key evidence, and this is, to me, the defense was celebrating this week on the free camera, but that defense, that Burgess testimony was key to me. Now it felt like sweet vindication for me too, because I
Yes.
put that together a year ago, and I
You did.
put together a sloppily, because I'm not good with graphics, but one of our regulars, chick from the bricks, cleaned it up, and I presented
Good.
that to the Discovery Eye people for the documentary a year ago. They didn't use it. I presented it many times to Court TV. They never use it. But I had that nailed down to the second. Now, look, it's not algebra. It wasn't difficult. It wasn't calculus. It was just based on the timelines that Trooper Garina gave out about the phone. But amazingly, the state didn't put any of that together last year.
No.
But
No.
I had it right down to the second, and so I feel somewhat vindicated by it. But it's
Yeah.
unshakable. You couldn't have manufactured it.
No.
It's
No.
that correlation is
So
the key. You could in theory make vehicle data, which is what they've tried to say in the past, of Trooper Proctor driving Karen's Lexus in the Canton police parking lot, for
Yeah.
70 feet. In theory, you could do that, but there's no way you could recreate that correlation with that all important phone data on John's phone, and that the
No.
3-point turn, the fact that the
Oh,
phone stopped moving.
perfect.
If you
Yeah.
can't recreate that, and
No, it was excellent. And yeah, James, I hope we answered your question. I think that the prosecution has already presented very compelling evidence. It's just going to be tied up this week. So hopefully you'll
right.
be able to watch it.
So I guess the last thought of that would be just, so we haven't got to, in fairness to the defense, we haven't got to hear their defense yet. We've got to hear their crosses, and we got to hear what they put through last time. What do you recommend for them for a strategy?
Who, the defense?
Defense, yeah.
For a strategy, obviously their cross examinations have been good. They've scored some points there, but like I said, they're going to be calling, Higgins and Albert and Proctor. I think they will. What else? Let's see. Who did they have on last? Oh, obviously they'll have their dog bite expert on. They'll have their Google guy, Richard Green, who I was not impressed with at all. And
Mhm.
I'm trying to think who they used last year for a accident reconstructionist, right? So they'll try to advance their own theories in that regard. I don't know who they had put on to counteract the Burgess testimony, though.
Somebody asked us to answer Joan Keefe's, and just so you guys understand, this seems to it's
Can
almost to the
Margaret
point.
answer? What?
It's almost to a point where it's difficult to take questions in chat because people get so mad at me when I don't see their question. I ask a question, and if Margaret's going to give a good answer, which she always does, it's going to take a few minutes. By the time
I
she
won't
answers
answer.
it,
I won't take a long time to give that one.
no, but by the
The
time you
laptop
answer a
one.
question, several more questions have gone
Oh,
by, and I have not been able to see all of them. And people don't seem to understand that, so they think I'm ignoring. It's very difficult to talk to you and literally monitor every single damn question in there. And we go through this every show, and people don't understand it. I don't mean this to solicit money,
you know what?
but
The next time, Kevin, I should. So I'm new, everybody. I'm new to YouTube. I have been podcasting, but I started my channel, I'd say in January. So I need subscribers. But anyway,
what's the name of the channel? So let's give it a plug.
It's a crime at It's a Crime Media. That's it.
Okay.
But what I'm wondering in the future, if we both put a stream up, if I could see the questions too, then maybe both of us can be looking at the questions. That's just an idea.
Yeah, I'm not
I have no
sure.
idea. Okay.
Yeah, so unless you logged in, so when I'm looking at the questions, I'm actually not looking at YouTube. I am looking at the streaming service Streamlink that I
Yes.
got you to get this
Yes.
morning. So there's an option on there, so that'll see the comments from all the other platforms that we're broadcasting in. So that's the one I look at. And now one option. So when you look in the top of that, there's the live. You can set it on live, or I can also. You won't be able to see it on yours, I don't think, because you're not live on it. But under starred questions, I can hit that, and that will show all the questions where people made a donation. Now, I'm
that's
not
cool.
doing this. I'm not
I know
doing
you're
this
not.
to solicit a donation, but I do go back to those. So if somebody donates the minimum amount that they allow, I don't know, a penny and 99 cents or whatever it is, I will get to your question. Otherwise, on the questions in chat, I try to get to them, but it's very, very difficult. So you have to accept the limitations of this. I'm not ignoring anybody's questions, and I just can never seem to get that through. So, all right. So let's go to Jones.
The laptop. Okay, yes. So I can easily answer that. Karen reads the defendant, and she's allowed to prepare for her defense, and they would definitely allow her a laptop.
Right. All right.
Times have changed.
Yeah. Oh, I mean, just in this, John DePetro was talking to me on the phone the other day about this, the difference in court with the sound and the size of the monitors. He's like, it's going to leave a powerful impression on the jury. Like when it comes on, you're like in a movie theater.
Yeah.
And
Yeah. He told me that as well. Like Karen, when they're showing Karen's clips, the Karen clips. Yeah. Yeah.
Yeah.
He was saying that he was saying like, all of a sudden they'll be listening to testimony from some expert. It'd be kind of boring. Then all of a sudden bring out the popcorn and they put on the big monitor and there's Karen. Yeah.
Such another outside the box strategy of playing these clips after testimony. And sometimes it's only loosely connected to the testimony too, which is kind of interesting to me. Is that you feel, but I'm sure this was all cleared legally beforehand, right? Is this going to be the basis of appeal down the road?
No, I mean, I don't think so. But putting the videos up, she put herself out there, and it's fair game. I mean, you can appeal on a number of things, but whether you win on appeal, that's the issue. And I don't think she'd win on that. She put herself out there, and I think it hurts her in a number of ways. I think it makes her look kind of callous, like, oh, you're capitalizing on the death of your boyfriend.
Right. So are you going to be able? I've invited Margaret to join our panel.
I would love to.
Trial with me and Matt and Jen and of course Kate, sometimes Drunken Turkeys, Boomer, and so I will include you in the links, and the way that is, you'll be able to come and go as you please.
Okay.
I get stuck. I got stuck last trial, and part of this trial with having to man down the whole fort for the whole 7 hours. But now
Yeah.
I've shifted a lot of that load onto poor Kate.
So I'm
So
happy to do that. That would be very interesting. I'd love to do something like that. And again, I appreciate everybody who's still listening. Kevin has been wonderful explaining to me. Again, I'm new at the YouTube and everything, but I'm getting there. I love it.
yeah,
Uh, Again, going from podcast. Actually, I did live radio. I had my own radio show back in the day. During the Whitey days and all that. And they made podcasts back in the day out of those, and I
yeah.
didn't even know what a podcast was. And then, thank God, I started that up again last year. And it was all because of my son. He's like, "Mom, you need to do this." Then he said, "Mom, you need to go on YouTube." I'm like, ah. So, but I'm actually enjoying it very much. Very
Well,
creative.
thank you for being here, Margaret. Actually, I'm gonna, if you don't mind, staying on for a couple
Yeah.
minutes privately, because I'm gonna end the show, but I'm gonna leave
Okay.
you in backstage, and then we can I want to discuss so you can set up be able to link to these,
Yeah, that'd be
and
great.
so let me just I'm gonna temporarily boot her, and then say to everybody, thank you very much for being here. So tomorrow night there'll be a panel discussion at 5 o'clock. Tuesday Gazette, Jen Coffindaffer, our own YCT legal counsel, Red Star. And I'll give Kate a call and see if she has time, and whoever else wants, from our regular panel that wants to come on and talk about it. But thank you, everybody. It's been fun. It was great having Margaret on, and it's really been good over the last month getting to know Margaret. So, like I said, we have a lot in common in terms of places we've been and stuff like that. Obviously, she's a lawyer. I'm an old doorman, DJ, bar owner, rough and tumble kind of guy. So different backgrounds in that way, but it was great having her on. So thank you much, everybody, for being here. And there are some new things in the works that I hope to be able to report you something with that on this week. And these are potentially some exciting things. Nothing to do with Karen Reed.